As we know, and Dr. Enrico and Priya will enhance, a standard essential patent is a patent that protects an invention essential to the implementation of a particular technology standard. And these standards are critical for ensuring safety, interoperability, and compatibility of different products and services made available by various companies. Another way that we can define a standard essential patent is to say that an ACP is a patent that must be infringed to practice the industry standard. And for that reason, there is so much litigation on this field, as we will see further. In Brazil, an interministerial working group was created by the federal government in the beginning of 2022 and finished its works on the beginning of 2023 to debate and study whether there would be a need for changes in Brazil legislations to treat SEPs differently. The conclusion of the study was divided into two different positions. One is that there would be no need for legislative changes on the subject, and the other position is that there's a need to at least provide a better clarification on SEPs to legal operators, including the judiciary. In addition, to continue to clarify the concept of friend and what would be fair and reasonable terms for the licensing of SEP patents, as we will discuss further today. And to discuss these matters, we will have with us Priya Nair, that is Senior Intellectual Property Policy Counsel at ACT, the EP Association, and Dr. Enrico Bonadio, that's the Reader in Intellectual Property Law in the City University of London. You are very welcome. Juliano wants to say some first words also?
Yeah, just to contextualize, given that our series of lives and webinars are mainly concerned with competition in digital markets, in particular competition by digital platforms and the efforts of regulation. And then now we are discussing SEP, and I see an important connection that later should foster more discussions among us here in this series, because actually we are discussing the entry barriers and possibility to enter and compete in this market. When you have the discussion about regulation of competition in platforms, the main concern is how market power in this field is impairing consumer ability to choose between different digital services. And one of the main concerns I see with SEP is the rise of IoT devices that are connected to the internet. And the ability of this device to meet the standards is crucial for companies to enter in this market and to have this device exchanging information and participation in the global internet. So actually, there is also a discussion whether the internet we know with user navigating social networks, etc., is the same thing as the internet of things where machines are all connected. There is also this discussion. Is this really internet, or internet is something else where you have humans choosing services and etc.? But in a parallel, there is, I think that the subject matter is the same. How is the decision to navigate and to choose among different services and participating in the web, participating in internet is effectively free, and there are enough opportunities for entry. So standards are somehow a barrier, but are important regulatory barriers so that you have interoperability and etc. But of course, when you have an essential item to be licensed, there is difficulties regarding bargaining. And so this must be overcome so that we have a free internet, not only for human users, but also for devices, for IoT devices. So I think these subject matter are a bit different, but they are somehow connected and concerned about competition and freedom in the internet.
In digital markets. Great, Juliano. Thank you. Let's give some steps behind. Let's open with a first question, basic question to situate the debate. So I would like to know, Priya and Dr. Enrico, what are standard essential patents? I give a quick definition, but I would like you to go further. And what industries do we see them existing in today? And it would be good also to talk a little about the standard organizations also, and their paper on this discussion, their role on this discussion.
Absolutely. I can start, and then Enrico, happy to hear your thoughts. And thank you to Legal Grounds, and thank you to Enrico for being here today. This is wonderful. As Bianca said, I'm the Senior IP Policy Counsel for ACT, the App Association. So we support small and medium-sized software developers that operate within this space, as well as other innovation streams. So as Bianca kind of highlighted, standard essential patents are very unique in that they live within this specific innovation stream, and that's around technical standards. Technical standards are developed through industry in a consensus-based process, and are developed so that developers can use, industry participants can use these technical standards in order to then develop new products and devices in industries to then deploy that and potentially develop more patentable innovations. And so standard essential patents are very important in this process, because as the specifications for technical standards are built out, they will obviously cover some specifications that are covered by previously or existing patents. And so while you can absolutely maintain your patent outside of the technical standard innovation stream, you can also contribute your patent to a technical standard to enable others to use the standard. And you do this when you contribute your patent to the standard. A standard development organization that houses that standard and also facilitates will oftentimes require you to make a commitment to license your standard essential patent on fair, reasonable, and non-discriminatory terms, or reasonable and non-discriminatory terms. So you'll hear the term FRAND and RAND. Oftentimes it's FRAND, but these terms are essentially a mechanism that the standard development organization has implemented to combat the obvious and inherent market power that a standard essential patent holder has in a certain technical standard. And so standard essential patents kind of live in this specific stream. And we saw a build out of this type of this way of innovation decades ago. And I think the first sightings were likely, in the mobile handset area, but now you're seeing it really everywhere. You're seeing telecom standards being used in different industries. You're seeing standard essential patents being implemented into devices and products that span from precision agriculture to green tech to broadcasting to automotives. Now even we're seeing some disputes with standard essential patent licensing in streaming devices. So it certainly has grown out from where it's been, but that's kind of a base, and I'll throw it to Enrico to add any light on that.
Thanks, Priya, for this introduction, which is very, very clear and explanatory, I would say. Just to introduce myself, I am an academic, a legal scholar specialized in intellectual property law at City University of London. And I've also been in the past an IP litigator. So I've been in the field of IP patents for 24, 25 years now. And I am also a fellow of the Innovators Nectar Foundation. And, the field of standard essential patents has been intriguing me for quite a while, I would say. I wrote my first paper, I think it's 12, 13 years ago, where the issue of standard essential patents was not so hot as it is today. Well, it was in America and the US, but in Europe and the other countries of the world, like Brazil, Colombia, Indonesia, it has become hot and so controversial as well in the latest years, with so much litigation, as Bianca has already said. I just want to add a specific angle to what Priya has already said. Here we have a tension between patents and standards, because patents give a monopoly, which is a quite fair monopoly. I mean, patents are important to stimulate innovation, right? We know that without patents, many companies in several industries would not invest. So that's important to recognize, right? The importance of patents. But when it comes to standardized technology, we have a conceptual tension, because patents tend to close, tend to monopolize. On the other hand, standards are open, in the sense that if companies, corporations want to enter that particular market, they need to adopt that standard. Otherwise, they are out of the market. And therefore, you can see how this tension emerges, right? The openness of standardization and the closeness, the monopoly of patents. And this creates a tension which makes us reflect about the need to give some redress, to make sure that this environment becomes as competitive as possible, because it's a sector which is different from other sectors where you don't have to adopt that standard to enter the market, right? And therefore, what we need to do is to take into account also principles which come from another area of law, which is competition law and antitrust law. And here, in this sector, you can see how competition law in several countries, EU, the US, has made sure that patent owners behave in a way which does benefit competition and ultimately consumers' interests, right? Because at the end of the day, who pays the price for expensive products because of overprotection of patents, because of strategic anti-competitive behavior, which sometimes patent owners carry out, who pays the price at the end of the day are the final consumers, not only the competitors, right? So this is a unique area of law where we need, as academics, as policymakers, as judges in case, we need to make efforts to find the balance, the right balance. And of course, as Priya already said, reaching FRAND licensing terms is crucial here. The problem is that the concept of FRAND around the world is not so clear, and there we have lots of litigations there, right? And of course, we will talk about it. But this just to introduce broadly, from a broad perspective, the discussion, the academic, policymakers, and judicial discussion.
Very good, Dr. Bonadio. Last year, at the end of April, the European Commission published its proposal for a regulation on standard essential patents, and that aims to facilitating the SEP licensing by increasing transparency about SEPs, reducing information asymmetries between the holders and the implementers, and facilitating the agreement on FRAND license. Europe has identified some drivers for the main problems with SEPs. One is there is insufficient transparency regarding SEP's ownership, who owns the patents. Furthermore, it's not certain that all patents sought to be licensed are really necessary for implementing a standard, so the essentiality. There's a lack of information, the second problem, there's a lack of information about FRAND royalties. Implementers will with little or no experience or resources find it impossible to assess the reasonableness of ACP's holders' royalty demand. And the third problem was that the proceedings before national courts are time and cost, as you know, and are not adapted to friend determination. In this context, I would like to ask you both, is the friend-rand commitment defined in any way? Are there guiding principles?
So my answer is going to be yes, there are guiding principles. But I think as far as the definition, I think it makes sense to take a step back and ask why FRAND and RAND are not defined so clearly in patent policies and IPR policies within a standard development organization. They do in their policies have oftentimes the FRAND and RAND commitment, but there are a lot of IPR policies within a standard development organizations that are quite thin, and there are some that are a little bit more defined. The reason being is because at the end of the day, these organizations are made up of technical experts, and their point of being and you know, their reason for housing these standards are purely objectively on a technical kind of basis. And so they do not want to enter kind of the legal disputes. They would like that to be kind of outside of their realm. And so that is why oftentimes in an IPR policy or patent policy, you won't see too many principles be pulled out in very defined in those policies. There, one that you likely will see in many or in some that are well defined is that the license for a standard essential patent must be available to all willing licensees. Or all licensees or all participants. They'll kind of define it, you know, phrase it in different ways, but essentially saying that there has to be licensing availability. And that's simply because that's the only way this particular innovation stream works. But I do believe that around the world, there has been decades of case law, guidance from patent offices and other agencies around the world. There have also been proposed regulations, as Bianca kind of alluded to, that do pull out principles that would define FRAND. And so one of those principles, again, is that the FRAND commitment means that the licenses do have to be available to all, and that does not mean without fair compensation, right? It does mean that, but it has to be a reasonable royalty rate, and it has to be under reasonable terms. Another principle that some courts have pulled out and some courts have not, and it is certainly a contentious part of this debate, and we'll certainly talk a little bit more about it, is that prohibitive orders like an injunction should be allowed in exceptional circumstances. The reason being, again, is because of this FRAND commitment. There is a promise that the SEP holder made to license on fair, reasonable, and non-discriminatory terms. And so because of that, there has to be a fair negotiation. And oftentimes that does mean that because this SEP holder did contribute and voluntarily contributed their patent to the technical standard, they do have to license fairly in that stream. They don't have to outside of the standard, but within the standard they do. There are also courts and guiding principles and jurisdictions that have put out guidance on, you know, defining royalties, which evaluation is another area that's pretty contentious, but some courts have delineated that at least at least the SEP has to reflect the value of the actual patented technology, not the inclusion in the standard, not extracting value from the device or product that is incorporating the SEP. Again, this is a principle that's been pulled out through different cases. And then just a couple more that I've seen around the world. Obviously, one area that's, again, a little bit contentious is patent territoriality. Some courts have decided that they can determine global FRAND rates. So that means a FRAND rate on a portfolio that has patents that are issued in other countries. And as we know, usually the country that issues a patent is the country that can determine the validity or determine if that patent is actually infringed. But in general, this is kind of one area where there's a little bit of dispute, and some countries have decided that they can determine global FRAND rates. But then kind of going back to maybe two areas that one Bianca did kind of highlight before is that sometimes there are SEP holders that will offer a standard essential patent, but only within a portfolio of other patents that might not be essential to the standard, or might not even be required by that specific licensee. And so these harmful tyings are not appropriate and should not be allowable. And some jurisdictions have provided that in guidance, some have not, some have proposed that in guidance. And then just maybe a last thing I'll say is some jurisdictions have also pulled out that when a SEP holder transfers, if they ever do transfer their standard essential patent that is FRAND committed to another holder, that patent still must be FRAND committed. So the FRAND commitment does transfer with the SEP itself, not the patent holder. And I think this is important both when the standard essential patent holder transfers, has already contributed their patent to the standard, and then subsequently transfers it to a new holder. But it also is incredibly important when we think about patent pools that are essentially agents of these standard essential patent holders, licensing agents of these standard essential patent holders. And there has been at least one large patent pool that is very significant in a lot of spaces that has decided that they are not beholden to the FRAND commitment, although they do license these standard essential patents on behalf of their patent pool members. And so that can be very dangerous. So obviously the answer to the definedness, there is absolutely, it's pretty thin, but I think when we look around the world and we look at decades of case law and guidance and proposals, we see a lot of the same principles being pulled out. And so I think that's at least indicative that there are certain principles that can define FRAND.
Well,
Enrico?
What can I add more? You you covered all of it, but I mean, there are different concepts of FRAND. Even there are different, let's say, different standard setting organizations have different, interpretation of FRAND, different guidelines, let's say. So the concept of FRAND can vary significantly across different standard setting organizations. For example, the voluntary nature of the commitment. Some standard setting organizations allow patent holder to decide voluntarily whether to commit to FRAND terms. And this obviously means that the extent and nature of the FRAND commitment can differ, based on the organization's requirements and the patent owner's willingness to comply. non-discrimination policies. Non-discrimination is the ND, not the last part of the FRAND concept. Is a common element across many standard setting organizations, but the specifics can vary. For example, some standard setting organizations may impose stricter requirements regarding what constitutes discrimination amongst licensees, potentially affecting how licenses are negotiated at a global level. Then, of course, Priya has already said about the global license approach. We know that there are some courts, I'm thinking about the UK courts with the decision of the Supreme Court in unwired patent, where the British judges have decided to be competent in establishing the global FRAND license. These, even where most sales have occurred in China or outside the British territories. So several commentators there have, including myself, have raised some eyebrows regarding the principle of territoriality of patents, right? Which is enshrined in the Paris Convention since the 19th century. So, but not only UK judges, even Chinese judges. No, here it seems have decided to determine a global FRAND license. It seems that the UK jurisdiction is more patent friendly, while the Chinese jurisdiction seem to be more oriented towards a more balanced approach. But here it seems that the courts are trying to attract litigation in their own territory by offering this global license. And then several other issues which also have been mentioned by Priya. The enforcement of FRAND commitments can differ based on the policies of the standard setting organization. So in some jurisdictions, for example, courts have taken a more active role in determining FRAND terms. Again, the British, for example, the Chinese. Whereas in continental Europe, for example, judges in Germany have explicitly refused to determine the FRAND license, limiting themselves to give some broad guidelines, right? Basically leaving the matter to market forces, let's say. Then other issues which are very important. Should the FRAND royalty be capped at the value of the technology itself before the standardization decision or not? Should the fee be based on components or on the final end product? Another issue over which there is no clarity across the different judiciaries in different countries. And also the use of comparable licenses, right? The comparables. We have seen some different approach from country to country, from judiciary to judiciary. So it's a bit of a mess. It's a bit of, the situation might be different from country to country. And this does not help global licensing. This does not help because, these licenses are often multi-jurisdictional, right? They touch different countries. And therefore, both patent owners and implementers need to navigate a territory where there are different concepts of FRAND, different... It's difficult, of course. As an academic, we need to try to provide clarity and stuff to give proposals. There have been proposals, probably more academic than practical, I would say, to create an international tribunal, a global arbitration, also relying on what WIPO has been proposing, but they remain still academic proposals, I'm afraid, and with not so much practical, repercussions. But this is the landscape, I would say. Yeah.
I have a question. Of course, the great problem here is to enhance competition and the barrier to enter that these Asian patents may imply. But then the problem actually is about transaction costs, no? How difficult it becomes to negotiate, given that there is an imbalance of bargaining power that's brought about by in the moment that you have an essential patent in the hands of the patent owner. But then there is a difficult because an intervention by the state or by a regulation to try to correct this imbalance may create a new imbalance now between the patent holder and the state that is intervening to impose some parameters into the licensing. So how can we avoid that and to reach a balancing instead of just inverting the bargaining power from the patent holder to the licensee?
I think that is a very difficult question, because if you look at kind of the history of the SEP landscape, it's kind of right, it's teetered a lot, but there has been quite an imbalance on the patent holder side, and that imbalance was supposed to be, in a perfect world, at least somewhat offset by the FRAND commitment. But there are certain things that happen in negotiation. First of all, there are a lot of negotiations where a licensee might be approached with a pretty restrictive non-disclosure agreement. And so that doesn't allow other licensees to be able to kind of see comparable licenses. Some licensees that might not have the resources to gather basic information of the patent, claim charts, and things like that might not have the resources to assess the essentiality, the validity of the patent, and if they are actually infringing. And obviously there are cases where everything is cut and dry, but oftentimes that's also not the case. And so sometimes licensees do have to accept licenses that might be super FRAND or not FRAND, with excessive fees. And we've seen this kind of activity not with a minority of SEP holders that are very large and kind of do this to a large group of licensees and consistently. And so that has been happening over time. And there have been proposals to kind of offset this balance, again, through regulation, yes. And certainly there is the concern, right? Like you said, that, we don't want to teeter too far so that now licensees have the upper hand, and we might see kind of opportunistic activity or, kind of abuse of this landscape from the licensee end. But I think what we would want to see in proposals that would bring a balance to this landscape, we would want to see more transparency for negotiations. So that does mean that there should be basic information offered to the licensee, or there should be public databases that the SEP holder provides basic information about their standard essential patent. There should be mechanisms in place to facilitate fair negotiation. And if all else fails, the court system is always there to support if a FRAND negotiation cannot come to an agreement. And so it's certainly a delicate balance. There's obviously there's a lot of argument in this space because of that, because there are a lot of folks that are both on both ends, and there are a lot of folks that are specifically on one end of kind of the conversation. And so it's certainly a delicate balance, but I think it's objectively true that there needs to be a little bit more transparency to facilitate fair negotiations. And you know, there have been proposals for mechanisms as well to facilitate this that might offset some of the kind of dominant positions that the SEP holder might have in these types of negotiations.
Yes, just to follow up, of course, the European Commission proposal has been the proposal has been put forward last year in April 2023. A big debate has followed such proposal, which was approved by the parliament, and I must say that what the proposal is trying to do is to rebalance a situation which was not balanced, right? In my opinion, by following on the footstep of what the Court of Justice said in the 2015 case YA, right? Because in that case, the Court of Justice basically told us, July 2015, told us that in order to get an injunction, you need, as a patent owner, you need to follow some steps, right? You can't just ask for an injunction like this, right? So this injection of some bureaucratic steps was already envisaged by the Court of Justice in 2015 with the decision in YA. Of course, the Commission now has backed up, right, such by not wiping out the enforcement rights of patent owners. Patent owners still have their enforcement rights. However, again, there are some steps, right, to be taken. Of course, we need to avoid that, as Priya said, we need to avoid that we end up in patent, hold out, patent, on the patent owner side, on the implementer side. We need to avoid the implementers adopt strategic steps to delay the negotiations. But I mean, it is not the first time that some bureaucratic steps are introduced into these schemes, also in other areas which are not IP areas. And then if we look also at other areas of IP, and just to give a broader context here, right? Not just with reference to our sector, patents, standard essential patents, and Internet of Things, also in other areas, which are far, but still patent owners' ability to exclude others are relaxed, right? Is relaxed. Think about access to medicines with the COVID-19 waiver. Think of other. So this idea that IP rights give an absolute power to request and obtain injunctions is not true. It's not true. Also looking at other areas of IP law, even if you look at trademarks, right? You may remember the tobacco packaging, plain packaging issues. I mean, there, tobacco majors have lost their ability to use the brands on the pack in many countries, not all, right? So also, if you look at other areas, this is not an absurdity. This is not a complete Copernican revolution of IP. IP gives monopolies, of course, but in certain sectors. In specific circumstances, such monopoly must be limited, relaxed, in the interest of a public good. And here the public good is competition, having always in mind the interest of final consumers. This just to give a broader perspective on IP. Also by looking at international treaties such as TRIPS agreement, we have public interest, competition related provisions in the TRIPS agreement, and so it doesn't seem to me that this proposal is too revolutionary, let's say, because it keeps enforcement rights for patent owners, provided that certain steps, with the EUIPO involvement, essentiality checks, and the FRAND guidelines, and so on and so forth. It's a unique sector which calls for sui generis, solutions, right? Because the alternative is the status quo ante. But the status quo ante does not work because we have seen behaviors which have been abusive. I'm thinking in Europe, for example, the Rambus case. You remember the patent ambush behaviors, Motorola, Samsung, and then hey, do we want to remain in the status quo, leaving the negotiations to market forces? And we know how in most of the times we'll end up with exorbitant licensing fees to be paid by those who want to enter a market. Do we want that? In my opinion, no, we need to intervene. Of course, then the proposal can be perfected. Of course, it's not untouchable, of course. But the main structure, to create some safeguards to address the issues that have been mentioned before, no? Information asymmetries. No, Bianca, you mentioned those before. Information asymmetries, the fact that many patents are not really essential at the end of the day. If we look at the data, there are some data which are very clear. I mean, less than 50%. By looking at some data in the Commission communication of 2017, I mean, that's really an important point to be considered. And then patent validity. Are you really sure that those patents are valid? Let's not forget that IP rights, not only patents, but trademarks, they are contingent rights. They can be invalidated. It's not like rights over tangible goods, our home, our car, no? They are contingent rights. Patent offices may get it wrong when granting the patent, right? I mean, we have an history of patents being cancelled. So having some mechanisms that double down on this, on checking the validity, checking the essentiality, in my opinion, is important. Then, of course, this does not and should not allow implementers to adopt the laying tactics. Of course, we need to be also vigilant on that. But we need some form of redressing mechanisms because the situation as it is now is unbalanced, in my opinion.
Great, Enrico. Cesar would like to ask a question also.
Well, I was really very curious about what's the most frequent problem that we have on this essential patent thicket. When Juliano Maranhão, Bianca, and myself, we are closer to the problem of antitrust, to dominant position, to competition policy issues. So we are used to big guys. So the problem is with the big guys. The guys who are huge, have a lot of patents, and they have a huge capacity to block the development of anything. But in this case, there's another problem, the problem of holdout. The problem can be huge. It can be worse when you have a huge provider of the technology, but you have a lot of smaller, very small providers of technology. And the point is, it's better for me to be a free rider and to be the last one to negotiate or to just to keep out and to charge very high fees. So I can be non-discriminatory. I can fulfill the non-discriminatory part of friend, but not the other ones. I'm not being fair because I'm charging a very high price because I'm the very last one guy to charge because my patent may be very, very small in the whole thicket of patents required for a given system that is required for something. But and the problem is not that the guys who supply patents are huge, but because they are very small. The point may be the opposite. So which one of those are more frequent in this case of essential patents?
So yeah, the concept of hold up and hold out has been evaluated on this landscape for quite a while, and That's an interesting scenario you pose. Actually, a lot of times I mean, at least in one case in the UK, they've actually seen kind of the, you know, that I don't think that it's often revealed that the non-discriminatory part is satisfied, and that you know, usually there is kind of a I guess, for example, there was a case in the UK where the court found that you know, a certain SEP holder was charging specific or you know, some of the licensees a certain fee, and then kind of taking a discount from that fee and then charging others with that fee. So certainly, unfortunately, I don't think we often see, and maybe I'm wrong, and Enrico can correct me on that, see kind of this non-discriminatory part be specifically satisfied. But, you know, the issue, I think, with holdup and holdout is that when we look at holdout, oftentimes it is theoretical. There's not so much evidence on that side that the licensee is holding out, because oftentimes they've built this technology and they need a license. And so they have no reason to, especially, for example, small businesses that we support have no reason to do that because they don't have the resources to do that. And oftentimes when holdout is being explained, there is not much evidence to kind of support that. But when we look at hold up, when we look at a SEP holder using tactics like the threat of an injunction or seeking an injunction to force a licensee into higher excessive terms and excessive royalty rates and unreasonable terms, that we have seen. We've seen it across the EU. We've seen it a lot in German courts. We've seen it in the UK. We've seen it in India. We've seen it in the US, and we're starting to see it in Brazil as well, all around the world. So there is actually, in my opinion, more evidence of this kind of idea of hold up. But I'll throw it to Enrico if he has any.
No, I think I have your same opinion. It seems to me that we lack evidence, empirical evidence of holdout, as far as I know. I mean, the studies that I looked at, both in America, especially in America, because in America, as I said, research has been conducted for more years, for longer years. So by looking at the studies, what I understood is that while we have evidence, lots of evidence of hold up, we have less evidence of hold out. This does not mean that it exists in some circumstances. Of course, there are. At the end of the day, you know, a few implementers might try to delay, right, and to try to get away with that, but not of the same scale as the hold up. I mean, this comes from my studies, from what I've seen by looking both at the American and the European, mainly American. Why? Because at the end of the day, SEP owners, patent owners have a weapon which nobody else has, which is the injunction. And this is a terrible weapon because it can close a business, right? And this is a weapon that implementers don't have, right? And when if an injunction is granted, preliminary, final, even on a particular aspect of the complex product, it doesn't matter. The complex product is kind of affected, right? And that's the weak point for implementers, right? So probably this lack of evidence comes from this weapon that patent owners have. And that's why the European Union, the Court of Justice, in the YA case of 2015, has clearly made the issuance of injunctions subject to certain conditions, right? So these kind of guidelines regarding the negotiations. Now, the offer must be made by the by the patent owner, then a counteroffer. Although I must say that after that decision of 2015 by the Court of Justice, the way such guidelines have been interpreted by courts in Germany, France, UK, because at that time UK was still a member of has been different. So we have still these problems. For example, now there is a case in Germany, right, where the Court of Munich, Munich court, where basically the German court tried to push their own interpretation of the guidance by saying, look, what the European Court of Justice said in 2015 was just a broad, flexible guidelines, steps that must then be implemented nationally and stuff. Well, as you may know, the European Commission has filed a brief in such a litigation by stressing the importance of following step by step the sequential, right, procedure delineated, formulated by the Court of Justice, especially by always preserving the freedom for the implementers to challenge the validity of the patent and essentiality, because this is important. In all steps of the negotiations, these must be maintained. I think it's fair. Why it is fair? Because on the one hand, you have the injunction as a weapon for the patent owner, which is a strong weapon. On the other hand, you need to give a counter weapon to the other party, which is challenging the validity of the patent and essentiality as well. It's like giving two countries which are warring the same level of weapons, right? Otherwise, the situation is unbalanced. No, Russia and Ukraine. Russia is like this, Ukraine is like this, right? So we need to give them an equal footing.
Level the
That's
field.
what, in my opinion, the Commission is trying to do. Rightly so, in my opinion.
Moving the discussion to Brazilian courts. In Brazil, standard essential patents must be treated as any other patent granted by the Brazilian Patent and Trademark Office, INP. And there's no special treatment for SEPs nor any limitations to the exclusionary rights granted to their holder, as Enrico was telling us as in other jurisdictions. The Brazilian IP law also does not require any prior negotiation of licenses or notice before the filing of a lawsuit seeking the enforcement of a patent. And the FRAND commitment, when you see the decisions, maybe raise it as a defense in patent enforcement lawsuits, and it is treated as a contractual obligation. In the case of foreign contracts, they will be interpreted according to the law of the country in which the obligations were constituted, and foreign law is treated as a matter of fact in Brazil courts. So the Brazilian IP law also provides that courts must grant preliminary injunctions to stop patent infringement. It's in our Article 209 of our intellectual property law, industrial property law actually, which is the remedy chosen by a law to provide effective patent injunction. Because here we don't have any punitive or enhanced damages available at the end of the lawsuit. So in the Brazilian context, the grant of an injunctive relief in disputes related to SEPs follows principles similar to those applied in other types of litigation, but with some particularities. The injunctive measures here are granted by judges on a provisional or final basis when there is evidence that the plaintiff is suffering or may suffer irreparable harm, or harm that is difficult to repair. However, when it comes to SEPs, the application of injunctions can be more complex, and it involves a lot of balancing the rights of the patent holder with the public interest in access to standardized technology, as you were saying, Enrico. And so I would like you to talk a little about what developments are we seeing in the Brazilian courts on SEP disputes?
That I'll throw that to you, Enrico. I know you've been looking into this a lot.
Yes. I've recently looked at this with two Brazilian lawyers. and we wrote a blog post because I was intrigued by the Brazilian situation, because what I knew before last year is that Brazil has gained international notoriety as in the past, especially as a plaintiff-friendly venues for SEP holders, right? In the past. And I have seen some disputes such as Ericsson versus TCT, Vringo versus ZTE, with courts granting patentees injunctions in preliminary proceedings, a trend which has continued afterwards with the Nokia versus Amazon, Mitsubishi versus SEMP, NEC versus SEMP, and also final injunctions again in DIVX versus Netflix, right? And what I learned by doing this research, let's say, on Brazilian landscape is that in the past, Brazilian courts have followed two different approaches. But of course, Bianca, interrupt me and correct me if I say something wrong in the details, of course, because of course I'm not a Brazilian lawyer, but I have studied a bit. So basically, they followed the two different approaches to issuing injunctions in patent cases. When dealing with preliminary injunctions, Brazilian courts have tended to consider their impact on defendants' businesses and also the public interest, because it's a preliminary injunction, it's urgent, the evidence is not assessed so completely, so thoroughly like in the trial, right? On the other hand, upon reaching the infringement finding, final injunctions have been granted quite easily, basically automatically. I mean, that's as far as I understand. Also, when it comes to standard essential patents in particular, it seems that Brazilian courts have often noted that there is no differentiation between normal patents and standard essential patents, which is a bit different from what happened in Europe, for example, right? For example, in Netflix, DIVX Netflix, focusing on this standard high-efficiency video coding, the defendant Netflix tried to raise FRAND issues defenses, both at the trial and in the appellate proceedings, by claiming that the patent owner behavior was kind of predatory because it was an NMP, basically, a non-practicing entity, seeking injunctions to press defendants into reaching a licensing agreement on non-FRAND, or what they thought were non-FRAND terms, but they didn't avoid the injunction as far as I understand. And there is an appeal pending now. But in another recent case, which seems to be still pending, I'm talking about Gorenge, DIVX versus Gorenge, before the Carioca court, before the Rio de Janeiro court. It seems that in this case, just a few months ago, the court seemed to be a bit more keen at least, to assess also the interest of implementers when discussing preliminary injunctions. For example, a preliminary injunction was initially granted to the patent owner, but it was lifted later, allowing the implementer to post a bond, basically, to continue the alleged infringing activity by posting a bond around $1,800,000, right? And similar decisions on this bond, right, instead of an injunction, a bond, have been reached in the Amazon case, still DIVX versus Amazon, again, Rio de Janeiro court, and Dolby versus TCL, still on the advanced audio coding standard, where the appellate judges allow the defendants to continue the activity by posting this bond. Well, this seems to be a little divergent, behaviors of judges. And I'm thinking, for example, in Europe, in the enforcement directive, we have a provision, which is Article 12, which says that injunctions should not be granted if monetary relief is more appropriate than injunctions, which is it's a solution, it's a remedy, an alternative remedy to injunctions, which fits particularly well into SEP scenarios, especially when there are NPEs, non-practicing entities, because at the end of the day, non-practicing entities are more often more interested in getting money instead of prohibiting the allegedly infringing behavior. They are NPEs. I mean, their business models is to attract licensing fees. They don't produce anything, right? And I think this free decision, which seems to be relatively recent, no, especially by the Rio de Janeiro court, it seems to me a remedy which goes into the right direction, because as I said before, injunctions, especially preliminary injunctions, but also final, but especially preliminary, because preliminary injunctions are not very well discussed, right? There is little evidence sometimes. So providing an alternative remedy of paying damages established by the courts or with guidelines by the court, instead of blocking a competitor like this, in my opinion, is reasonable. In Europe, it is, as I said, it is expressly statutorily provided by the enforcement directive. But also in America, no, we have sometimes remedies like this, Priya, right? And I pass the baton to you.
Yeah, I know we're running low on time. I think just from a global viewpoint, obviously, it's very seeing Brazil, the Brazilian courts treat standard essential patent disputes as any other patent dispute, makes sense at the outset because they've never seen these types of disputes. And then they came very fast. And so the more that Brazilian policymakers can educate themselves on the standard essential patent landscape and understand really why there is a distinction, and then look towards more markets that have a lot of experience with these types of disputes, like the European Union, like the UK, like the United States, they may find that there are mechanisms, like Enrico said, that need to be there to offset this powerful mechanism that a SEP holder has, which is injunctive relief. And so in the United States, you have a proportionality assessment that the courts use. It's called the eBay test. It's a 4-factor test that essentially allows the court to determine whether an injunction should be awarded in a patent dispute. In fact, that same test is a test more broadly used in other cases. It's this test of equity to kind of determine the balance of equities. And as Enrico also said, in the EU, they did implement a specific test in SEP circumstances where there are SEP disputes. The Huawei VZT, the Court of Justice decision in 2015, and that also were steps laid out for a court to determine if a SEP holder should receive an injunction in this case. And of course, as Enrico said, there are courts like Germany that have misinterpreted, and in fact, the Commission has even stated that in an amicus brief submitted in that case, that they have misinterpreted this case, which is, another significant reason for the implementation of something like the EU SEP regulation that's being proposed and considered right now. And so I think over time, Brazil will see more and more of these cases and will hopefully look to jurisdictions that have more experience in this landscape and that have started to implement certain solutions and hopefully take those into consideration.
Sorry, I just wanted to add something with reference to the decision, to the case, the Brazilian case, a few months ago, the Gorenje case, the IBEX Gorenje. because in May 24, in an interim order, the Brazilian judge gave some guidelines regarding preliminary injunction in Brazilian SEP cases. For example, the court, as far as I understand, noted that before obtaining such injunction orders, SEP owners have the burden of demonstrating that they have offered the license on franc terms. It didn't go into detail on what franc means, but the judge, as far as I understand, emphasized that the non-discrimination aspect is the most important criteria to assess franc compliance. It was not a detailed guidelines, of course, but it's, as far as I understand, it is the first time that a Brazilian court highlights that patentees should comply with franc obligations, which means something. Maybe it's a kind of a turning point. Of course, we know that Brazil is not a common law jurisdiction, it's a civil law jurisdiction, so there is no stare decisis, no, the president, but still, it might have a persuasive force also towards future judges in other states of Brazil. What do you think, Bianca?
Actually, as the Brazilian Patent and Trade Office is always on the litigation, it's almost, they are all or in Rio or in Brasilia.
Okay.
So because of this, you see a lot of things in Rio. And you were correct. Since 2015 or maybe before, the decisions always says that there's no legal provision that the essentiality of a patent has been recognized or declared. If there's no, sorry, let me rephrase this. The judges also always says that there is no legal provision that the essentiality of a patent has been recognized or declared. The Brazilian PTO must make such a note in the respective register. And as it doesn't have, so for them, they're the same. SAP or regular is the same. And Brazil is a pro-patent jurisdiction, where since 2012, friend commitments do not prevent the grant and the enforcement of injunctions and preliminary injunctions in the great majority of the lawsuits seeking the enforcement of SEPs. So this decision that you brought is really a point of inflection, because our system is not like this. And even the Superior Court of Justice in Brazil has explicitly decided that due to political circumstances in Brazil, an injunction is the only adequate remedy against patent infringement of any kind. So this, I think that's from 2017, this decision of the Superior Court here. So really, I think we are evolving in this matter, because it was treated like both the same. That's SEPs and regular patents is the same for the courts. No big difference. And when you think about CADE, I think you see some decisions of CADE that there's no provision under any Brazilian law establishing that the enforcement of an SEP constitutes an antitrust violation or any type of abuse of a dominant position. So there's no presumption of a dominant position for holders of SEPs. And CADE, in some cases, has rejected the claims and found that an SEP enforcement case is a private matter to be resolved in a private dispute, not warranting the interference of the government, and it does, if it does not really harm competition. So it's always taken to the courts. Well, we have little time now, and I would like to ask you two final questions, okay? First one, are there solutions to curb anti-competitive tactics in SEP licensing that are being proposed or implemented in other jurisdictions? And what we can learn here from other jurisdictions, what steps we can take maybe in Brazil to approach a rapidly developing SEP landscape here?
Yeah, I think, some of the things that I said before is obviously Brazil has its own, you know, approach to patent disputes generally, and will have to develop what it believes is the appropriate approach to standard essential patents. But what they can do is turn to these more experienced jurisdictions in this specific type of dispute and look at the solutions that they're implementing now. And be vigilant about how those solutions are, you know, developing, and what the you know, benefits and what the maybe things that can be improved by those solutions, and take that and see if it works and if it fits into the Brazilian landscape. So, you know, proportionality tests certainly do not hamper, in my opinion, a pro-patent landscape. I think proportionality tests, actually what they do is find a balance for competition. And you know, jurisdictions like the United States have implemented this more broadly than standard essential patents, because they've found that over time, the patent landscape and innovation landscape continue to develop, and there continues to be more and more different unique ways that innovators are operating. And so that requires a very flexible approach to determining really extreme mechanisms like an injunctive relief.
Just to follow up very shortly, yes, as Priya said, Brazil could watch abroad the developments in the European Union and the US, and some other areas that might adopt the same direction, right? To balance the power of patentees in order to protect competition and finally consumers. But the reason why, in my opinion, we need to go towards that direction is the fact that sometimes there is a misconception that implementers are they just adopt technologies developed by others. Of course, they do that, but they also innovate often based on such technologies developed by some others. And therefore, we need to bring clarity, because implementers also bring innovation, and therefore giving them more access at terms and conditions which are fair and reasonable and non-discriminating, goes also into the direction of guaranteeing and stimulating more innovation, so-called downstream innovation, right? The upstream innovation is the one of the SEP holders. But implementers which have the ability of accessing the, you know, easily or, you know, fairly the technology upstream, most of them, they will develop downstream innovation, and this is in the interest of everybody. And with this, I conclude.
Great, thank you very much. It was very interesting. We are running out of time, but it's a very important matter, although SEPs represent only a tiny fraction of the total of the patents that are currently in force. We see that SEP licensing is increasingly crucial for industries as communications, computer technology, audiovisual, and in which technical standards have become ubiquitous. So it's a very important discussion for Brazil, and it's important that we debate the matter, that we maybe create guidelines on SEPs and friend terms as educational tools for system users, for patent holders, patent implementers, for courts also, and to support discussions on the topic with multilateral organizations like YPO and YTO. Thank you very much, Dr. Enrico. Thank you very much, Priya, to bring the matter, and see you in a next episode. Bye-bye.
Thank you. Bye.